Hi, I'm Reed Bloodworth, Managing Partner of Bloodworth Law, with offices in Orlando and Winter Haven, Florida. Bloodworth Law serves as counsel for Florida businesses of all sizes across the state. Our employment law team can work with you remotely via video conference or in the office with the appropriate safety measures taken to protect you as we help you with your legal issues. For this video, I'm going to discuss 5 ways to clarify your exempt employee classifications. The exemptions I'm referring to in particular are the exemptions from the Fair Labor Standards Act for minimum wage and overtime requirements. The first one would be to make sure your job description is in writing. You'd be surprised at how many cases are litigated where there isn't a written job description for an employee. So just having to prove after the fact what the employee was actually doing. The second thing is to make sure that the job description is an accurate reflection of what that employee actually does, and to review that on at least an annual basis. Here's an example. If an employer is claiming the benefit of the executive exemption, the executive exemption requires an employee to supervise 2 or more full-time employees or their equivalent. If you do not supervise at least 2 employees or the equivalent of 2 full-time employees, then you do not qualify for the executive exemption. And employers will sometimes create positions and classify them as exempt per the executive exemption, and that employee supervising 2 or 3 people. But then one of those people leaves and it's not replaced. Maybe the other person drops back to part-time. So over the course of the year, that exempt employee has dropped below the 2 full-time equivalent employees that they are supervising, but the classification hasn't changed. In that situation, the employer is potentially liable for minimum wage and overtime for that employee that they had properly classified before, but have now misclassified. Another thing that happens is a position may be given a lot of discretion. And one of the exemptions is the administrative exemption. The administrative exemption requires the employee to exercise discretion and independent judgment on matters of significance. This is usually a high-level employee, like a marketing director or CFO, that doesn't necessarily supervise a lot of people, but does a lot of high-level administrative decision-making for the internal operations and controls of the company. You may have a situation where it's a really small company, and the person that they call their CFO actually ends up, as business develops, doing more and more bookkeeping and less accounting, which has been deferred to the company's accountant. So as this person's job has migrated from a higher level to a more clerical level, if this classification is not reviewed and changed, that could become a major problem. We recommend that employers, when you do your annual review of your employee, which you should be doing anyway, you sit down with the job description and say, are you still doing this? Are you still doing that? A lot of times you'll find out that the employee is actually doing on a day-to-day, maybe without even the employer really knowing, is different than what's in the job description. And you should ask, is there anything else you're spending time on that isn't on this list? And the employee might say, well, yeah, we lost our shipping and receiving clerk last year, so I spent half my time filling in doing that job in addition to my own. Well, that's not exempt work. So if they're spending a lot of extra time doing non-exempt things, you could have an issue there. Number 3, plan a meeting with your employees to review whether they meet the Department of Labor requirements. The Department of Labor has a really good series of what they call fact sheets for each exemption. And there's a lot of examples in there. There are also specific publications, guidance, and information available from the Department of Labor, Wage and Hour Division, related to specific occupations. So checking your exemptions against that guidance is very helpful. Very important. Document the fact you did this. Make sure whatever you look at to help say, yes, it looks like this person meets these requirements. Save a copy of that in the record and have the person who made this decision send an email to the file or something that says, I reviewed employee X's job description against the Department of Labor guidance, which I've put in the personnel file and determined that yes, this person still appears to meet the requirements of the exemption. Again, because showing the effort helps potentially reduce your damages, even if it turns out you're wrong. Number 4, there are a lot of borderline cases where it's not real clear if someone is exempt or not. If that person's paid a good salary and does not work much or any overtime, it's no big deal because even if the person has misclassified, they're not framed by that. And certainly there are some employees who are clearly exempt who might not work a lot of hours. So if you've got an attorney or a doctor or someone like that that's working 80 hours a week, you don't really have to worry about that person suing you for overtime. But if you have someone who's borderline, like maybe a senior bookkeeper or someone where it's not real clear which side of the line they fall on, you want to be really concerned about that person working a lot of overtime because that's where your exposure is. It's the number of hours that person works because you might be asking them to do more and not realizing it. The reason that employers misclassify people is because they're trying to save money and not have to pay overtime. So misclassification is of no consequence whatsoever if the person's not working any overtime and is paid at least minimum wage. But if you've got somebody that's working overtime and their classification is borderline, that's a high level of risk for you, the employer. But if you've got someone who is misclassified who basically works 40 hours each week, even if you're wrong, that's not a big deal. So that's not as big a red flag as someone who's putting in 80 hours a week who might be misclassified. And finally, number 5, consult with an attorney for borderline cases, A, to make sure you get it right for any borderline cases, and B, to help reduce your damages even if you get it wrong. Because consulting with an attorney can help you prove good faith. And if you can prove good faith, you owe less money in the event you made an error. By regularly consulting with an employment attorney, you're able to clarify your exempt employee classifications and ensure you comply with Florida employment law. I hope you found this video helpful. Again, I'm Reed Bloodworth, the managing partner of Bloodworth Law. Let's talk about how Bloodworth Law can help you, your employees, and your business.